Welcome to the Judicial Committee of the Privy Council. This is the hearing in an appeal by Presidential Insurance Company Limited against an order of the Court of Appeal of Trinidad and Tobago in relation to a third-party motor insurance claim by Emily Twitz, the mother of a young man who died as a result of injuries sustained in a road traffic accident. Today, the appellants are represented by Mr. Raj Kumar, Mr. Tika Singh, and Ms. Maiju Patrick. And Emily Twitz, the first respondent, is represented by Mr. Ronnie Prasad and Mr. Ronaldo Fall. I will introduce each of the justices who is sitting on this appeal before inviting Mr. Raj Kumar to make his submissions. I am Lord Hodge, and as it is the morning in Trinidad and Tobago, while it is the afternoon here in the United Kingdom, I will say good morning. Lord Lloyd-Jones.
Good morning.
Lord Briggs. Lord Hamlin.
Good morning.
Lord Burrows.
Good morning.
Mr. Raj Kumar, I invite you now to make your submissions.
I'm most grateful to you, my lord. My lord, may I also perhaps follow in you say good morning, but it is afternoon in Trinidad and Tobago. My lord, this is an appeal that raises 4 issues of law and fact, and it concerns in particular the very important question of who is an owner for the purposes of what I will call the Motor Vehicle Third-Party Insurance Act. And in particular, my lord, it goes on to consider what is the failure to comply with the statutory requirements under the Motor Vehicle and Road Traffic Act, which is a separate act, to transfer a vehicle within 7 days of sale and departing of possession. My lord, we will also submit as a secondary issue that this was a sale that was governed by the Sales of Good Act in our jurisdiction, and that the Hire Purchase Act, or as a credit sales agreement as defined under that act, did not and could not apply. Lord, we will go on to argue as an issue that the effect of the transfer of possession and sale meant that the insurance policy no longer was valid or was void in that it affected insurable interest. Yesterday, my lord, the appellant sought to put before the court a bundle of documents and further authorities that had been left out of the original bundle. Lord, I hope that that is before you.
We received a supplementary bundle yesterday, thank you.
My lord, and there are several documents in that bundle to which I would wish to refer. In particular, my lord, new proceedings that were filed after this matter, and a certified copy of registration that's annexed to there too. Now, my lord, may I frontally say that the certified copy was available at the time of trial, and for some very, perhaps the best I could say, inexplicable reason, was unfortunately not put before the trial judge. And I say that because, my lord, it leads to a strange conclusion that the court may have not had all the proper evidence before it in order to come to for the trial judge to come to a determination of the issue. My lord, may I therefore go there and start with the supplemental the supplemental bundle that points to the matter of Sanka and Presidential Insurance Company. Now, my lord, that appears at the bundle. I have it, my lord, as EB 181 in the supplemental bundle. And my lord will see that there is a statement of case, which is based on the very same accident, very same motor vehicles that was involved in the collision that now engages your attention. At page 209.
At what page, please?
If you just bear with me, the defense appears, the claim form is at page 151 of 157 of EB electronic bundle, of the supplemental bundle. And my lord, I refer in particular to page 158. The allegation, the first defendant was on the 2nd of February, the owner and at all material times, the driver of the motor vehicle registration 4059, which is the registered number of the vehicle. The defense filed by the Presidential Insurance Company, who's the appellant in this matter, is at page EB 181. And my lord will see there paragraph 8 of that defense, which is at EB 183. There is a next and marked C to those pleadings, a certified copy of the registration card for PBO 4059. My lord will see that that shows that as at 2014, the vehicle had not yet been registered in the name.
Mr. Prasad wants to intervene at this stage. Mr. Prasad.
My lord, perhaps at this stage I may indicate that objection has been taken, has been indicated to the appellant and to the registrar that we are taking objection to the board's consideration of these documents.
Yes, right. Well, shall we look at it, what we'd say, de bene esse, subject to your objection, and if we uphold your objection, then we will disregard this material.
And obliged.
Yes, we'll proceed on that basis. Mr. Rajkumar.
Thank you very much, my lord. My lord will see then that at 2014, the certified copy does not have the name Dexter Ramphal as being the registered owner. This means, my lord, at the time of the trial in this matter, he could not have been registered with the licensing authority in Trinidad and Tobago as claimed.
How does this arise before us at all, Mr. Rajkumar? This wasn't, don't interrupt please, this wasn't evidence put before the trial judge. So why are you leading evidence in from the pleadings in another case?
My lord, I'm leading pleadings from another case, and in particular reference to the certified copy for two reasons. The first is, my lord, that if the board was to come to the conclusion that the judge was right and Mr. Ramphal was the registered owner, you have a trial that is coming up where that in itself is challenged and there's documentary evidence that suggests otherwise. This could lead to an inconsistent decision, my lord, with regards to the same facts.
Well, I mean, we can't, I don't think that the Privy Council, the board can go into evidence that is being led in another trial, which is yet to take place. And you are saying that it would disclose that at the time of the trial in 2014, he'd ceased to be the registered owner.
In fact, my lord, we will say he was never the registered owner from 2009, when he claimed to be the registered owner, up until 2014 when the certified copy was obtained from the authority.
But you haven't made any application to this court to lead fresh evidence. This was evidence which you could have researched, or those who preceded you in this case could have researched in advance of the trial, because if you'd gone to the licensing office, you could have found out who was the registered owner. What possible basis, when you're faced with concurrent findings of fact, do you have for seeking to put before the board evidence that was not put before the trial judge?
My lord, the only basis I have is that the court is being invited to come to a conclusion where there's clear public authority documents to the contrary. My lord, I have no explanation as to why those at the trial did not refer or try to lead evidence to the certified copy, save and except, my lord, and as I'm instructed, that there was a misunderstanding of the effect of Section 12 of the Motor Vehicles and Road Traffic Act, that casts a burden on the owner of the vehicle to produce a certified copy in certain circumstances which are not relevant to the law of insurance.
Yes.
But what you would have, my lord, is a situation where the facts are they're supposed to be the same in both cases. It is the same accident, same motor vehicle. And what will happen is you're going to have a challenge to a final finding of the ownership of a vehicle where a registered owner is in fact not the registered owner on the documents that are on the pleadings. And it is clearly made out on the certified copy that he was never the registered owner of the vehicle at all, as most unfortunately, Madam Justice Jones, as she then was, determined, simply because it wasn't put before her. Now, in the course of the arguments, the question of the certified copy was raised more than once. And in fact, counsel preceded me at the trial in the course of her address did refer to the certified copy, but it was never produced. I have no understanding as to why it wasn't produced at the Court of Appeal, my lord.
But if it wasn't produced at first instance, when it could have been produced by either party, why, on what legal basis do you have for trying to introduce new evidence before the board?
My lord, it would mean, the only basis I have, and I rely on the very old case of Ming and Fleming, of course, that the decision of the court is flawed in that public documents or public evidence of a document is inconsistent with, or in fact undermines the decision of the High Court. And certainly, my lord, that means that if the decision is allowed to stand in the face of a public document, which is admissible as prima facie evidence under our Evidence Act, that the court would have gotten it wrong in a matter. There's a likelihood that if the trial goes on in the matter I've asked to put before you under the principle in Craven and Smith, that a second trial court on the very same evidence may come to a different conclusion.
Well, it's not the critical point. It's not the same evidence.
the new presence of the certified copy, my lord.
Well, there's the certified copy, which you say says something. Well, I'm going to allow you to develop this submission because you've only a certain amount of time allocated to you. But I am allowing it to go under a reservation of the objection, which may well have a great deal of force.
Indeed, my lord, I'm grateful. My lord, should I proceed then into the main argument?
Please do.
Thank you very much, my lord. Now, my lord, in both the appellate court and the first instance, my lord, there was a reliance on the definition of ownership in the Motor Vehicle and Road Traffic Act, which in itself, my lord, is set out in the bundle, and I will come to it in a few moments. There was a reference in the Court of Appeal to the Sales of Good Act, which, my lord, we say does apply in these circumstances. There was a reference, my lord, to the Hire Purchase Act. Now, my lord, the Hire Purchase Act does not apply for two reasons. The Hire Purchase Act deals with goods that are under the value of $15,000 at Section 3. And by Section 2, a credit arrangement requires installments of more than 5 payments. And even if that, my lord, even if her ladyship was correct to determine that there was some sort of payment schedule. We submit, my lord, that the case required a close analysis of the facts, including a determination under the Sale of Goods Act as to when title in the motor vehicle passed. And for that reason, my lord, we look at this, I take my lords to the Sale of Goods Act, which is at the electric bundle, page 1600, and in particular at 1605. And my lord will see at section 19, which is at page 1612, 1, where there is a contract for the sale of specific or ascertained goods, the property in them is transferred to the buyer at such time as the parties to the contract intend it to be transferred. And my lord, if you go down to the section 20, unless a different intention appears, the following rules for ascertaining the intention of the parties at the time at which the property and goods is to pass, my lord, is where there is, and I'm relying in particular on subsection 1A, where there is an unconditional contract for sale of goods in a deliverable state, and Lord, we say that falls squarely on the description of the motor vehicle. The property in the good passes to the buyer when the contract is made. And Lord, the evidence in this case is the contract as evidenced by the contemporaneous note or the receipt in September 2010 would have passed at that time. And the section goes...
I'm sorry to interrupt you, Mr. Raj Kumar, but this is a matter which the learned trial judge has addressed, and she has held, based on the evidence before her, that the contract arranged for the property in the car to pass on the transfer of the registered license.
My lord, I would say that is a mistake, an error of law, because the section 20 subsection A goes on to say, and it is immaterial where the time of payment or the time of delivery or both is postponed. Now, the evidence emerged that there were 2 failed attempts to transfer the vehicle, and there's no explanation as to why those attempts failed, but there certainly was evidence that there was an attempt to transfer. And in the circumstances, I'm sorry.
But the evidence, I think, was it not, that the second respondent's aunt was to pay a final instalment of £5,000 at the licensing office, and at that point the transfer would be made.
Indeed, no, that was the that after the transfer was made, he would receive the final payment of $5,000. But my lord, we suggest that that evidence was inconsistent with the contemporaneous document, which was a receipt which said in September he received $75,000. And when I come to the questions of inconsistency and incredibilities in the evidence, Raphael, I would say that was not.
How do you get over the practice of the board not to interfere and not to allow an examination of the facts when there are concurrent findings of fact? I'm thinking of cases such as Central Bank of Ecuador, Desir, and Al Sadiq.
My lord, I would ask you to look at the third point in the case of the central bank, my lord. In particular, it's set out in my friend's authorities, Al Sadiq. And my lord, this is a matter, for a moment, my lord, I've just lost a page on the tape. If just bear with me a second. I'm looking for where's my bundle of authorities? My lord, just bear with me a second. The one with the authorities. My lord, there's the third element of the 3 questions to be asked. My lord, and we say that, in particular, in the opinion of the board in the Bahama Air case, as is set out at page 14 of that opinion, at the electronic bundle 823, the third ground, the principle of restraint, does not mean that the appellate court is never justified, indeed required, to intervene. The principle rests upon the assumption the judge has taken proper advantage of hearing, of having heard and seen the witnesses, and has in that connection tested their evidence by reference to the correct understanding of the issues against the background of the material available and the inherent probabilities. Lord, we say this is the area that my lords have the power to intervene, and we say that when my lords look at the various questions and the facts, that the judge did not take proper advantage of the background material, and that would have been the receipt, which did not show a part payment or payment plan, and that there were inherent probabilities that arose both in the conduct before the accident and after the accident. And that would justify the intervention of the board, my lord. My lord, I apologize for the delay. And therefore, my lord, we say that this in fact leads to an error of law in the application of the Sale of Goods Act by failing to take into account the conduct of the parties, the contemporaneous note, and clearly, therefore, it was always the intention in September 2010 that title in the car would have passed. My Lord, we would submit that the conduct of the parties which are relevant is that in September, the aunt, if I may use the word aunt, took possession of the car. And Lord would see that at the electronic bundle, page 347 at lines 11 to 14. The car was always kept at the aunt's home, the electronic bundle, page 347, lines 18 to 19, and 354, lines 14 to 15. My Lord, we've taken the liberty in this supplemental bundle of relying on Google Maps so that my lords may appreciate the distance of the location of where Dexter Amphal lived in Siparia to his aunt's home in Mayaro, a distance of some 88 kilometers, and which the estimated time between the two locations is 2 hours, just over 2 hours. The fact that there were 2 failed attempts to transfer the vehicle prior to the accident, my Lord will see at EB 345, lines 5 to 9 and line 27. We would submit, my Lord, that even when he did use it, on the 3 occasions when he said he used it, the vehicle would be used and returned on the very same day. And the aunt had exclusive possession and control during the week. Note I refer you to the electronic bundle, page 349, lines 5 to 8, and line 22 to 25. His conduct post-accident, first of all, my Lord, that he was unaware of the accident for a few weeks, at electronic bundle, page 353, lines 10 to 11. He seems to have lost track of the whereabouts of the vehicle, or if I may use the word, the wreckage. I'm certainly not sure what it is. At electronic bundle, page 353, line 80 to 22. And therefore, he has no idea what has become of or where the vehicle is. And in the electronic bundle under cross-examination at page 351, lines 2 to 8, he has never recovered the so-called outstanding balance, my Lord. Frontally, my Lord, and I want to be frank with the board, the fact that he renewed the insurance in December 2010 may be an issue that the board will wish to consider as to whether it was connected to possession and control.
So what's that?
My Lord, in December 2010, Mr. Dexter Amphal went back to the insurance company and renewed his insurance.
I know that, yes, but...
By which time possession and control had passed.
Yes.
It is of no moment as to ownership. It was simply a transaction on his part.
Well, I don't really follow that. I mean, why would someone who had no ownership and no insurable interest in a car choose to renew the policy?
Well, I put it this way. In the course of his cross-examination, he did say that the aunt needed to drive the car even to get to the licensing authority. And I suspect that that was the purpose of renewing the policy. Because it's clearly the evidence that he had parted with possession and control.
I see. Thank you.
My Lord, may I then go back then to the definition and why we say that the definition is not limited to the definition under the Road Traffic Act, but rather is a more expansive definition for the purposes of the Third-Party Insurance Risks Act. Now, my Lord, the definition of ownership under the Road Traffic Act is set out in Section 2. And my Lord would see that it is set out in the electronic bundle. And my Lord, owner under the Road Traffic Act, indicate for the purposes of the Road Traffic Act.
Well, could you give me the electronic bundle number, please?
My Lord, I think it is electronic bundle number, page number 1146. Is that it? Just make sure it's correct. I'm just confirming that because I seem to have mixed up in my notes. And I'm just sorting it out. But, yes. 1146. Yes, no, it is 1146. My Lord, the definition of owners appear there for the purposes of that act. Is in the case of a motor vehicle that is not registered.
You referred to 1146, which is the Motor Vehicles Insurance Third Parties Risks Act. I thought you were taking.
I'm just trying to confirm it on the page. Where is it? Thank you very much. It's 1187. I do apologize, my Lord.
Thank you.
And my Lord would see the definition there for the purposes of the Road Traffic Act is that in the case of a vehicle that is not registered, includes the person in actual charge or possession of the vehicle. In the case of a vehicle that is registered, means the person in whose name the vehicle is registered. Provided that in the case of a motor vehicle, which is the subject of a hire purchase agreement, it means the person in possession of the vehicle under that agreement. And whenever the registered owner of a motor vehicle is absent from Trinidad and Tobago, the person in actual charge or possession of the vehicle in Trinidad and Tobago shall be deemed to be the owner thereof. That, my Lord, is the entire definition for the purposes of the Road Traffic Act. Under the Motor Vehicles, the Insurance Third Party Risk Act, which, my Lord, I hope I have it correctly now, is at EB 1146. The definition of owner is at 1151. And in relation to that act, it says owner in relation to a vehicle which is the subject of a hire agreement or hire purchase agreement means the person in possession of the vehicle under that agreement.
Lord Lloyd-Jones.
We've lost the sound, I'm afraid.
Yes, I think Mr. Raj Kumar, you pressed or someone muted you for a second there. But did anyone have a question to ask? No? No.
Right, I'm grateful.
If you could go back, you were talking about the Third Party Risks Act. You were looking at 151, and you read a definition of owner for the purposes of a hire or hire purchase agreement. But of course, it's not a definition for any other purpose.
That is so, my Lord. And of course, that is the definition given under the Motor Vehicles Insurance and Third Party Risks Act. And therefore, my Lord, we suggest or we submit that owner must take its common law meaning, which must by definition include the person in possession and control, of which registration would be a factor.
Well, I wonder about that, Mr. Raj Kumar, because if the context is a sale of goods, and one had allowed someone else to possess the goods at a stage before title had passed, because you'd agreed that title would only pass on the occurrence of a subsequent event, then possession wouldn't give you the answer, would it?
My Lord, I think that possession, if there was a subsequent event or a conditional sales agreement in existence, well then no, possession will only pass when the condition is met.
Yes. So, I mean, if the learned judge was correct that the parties intended property in the car to pass at the point that the final installment was paid, which in turn was to be achieved at the licensing office when the transfer was made, then possession would not give you a complete answer.
It would not give me a complete answer, my Lord, but then I would take my Lords back to the faculty of control and the manner of the control that was exercised as turned out in the evidence.
Thank you.
Lord, I go further, that the statute requires that a transfer be effected within 7 days of departing of possession. And that statute at section 19, my Lord, of the section 19 of the Road Traffic Act makes it a criminal offense not to comply with that 7-day requirement.
Can you give us take us to the provision, please?
I will indeed, my Lord. Section 19. The act itself begins at 11. Just bear me a moment, my Lord. I seem to. My Lord, at page EB 1212, section 19.1, subsection 19.1a, the motor vehicle shall not be used for more than 7 days after such change of possession unless the new owner is registered as the owner thereof.
Yes, so there has to be a new owner. It's the change of possession to a new owner.
My Lord, we say that the receipt clearly reflects that there was a new owner. The conduct, both before the accident and after the accident, reflects that there was a new owner. And that the failure to comply with this act, my Lord, at subsection 5 of the same section 19, where a registration of transfer of a used motor vehicle has not been made within 7 days after the change of possession of that vehicle in accordance with subsection 1A, the registered owner shall be liable to pay the licensing authority a penalty of $200. So, my Lord, it carries with it a penalty. And it carries with it the intention of the draftsman to ensure that the registration is up to date on the transfer of possession and control. And I add in the words control, my Lord, because it is clear from the evidence as we submit that control was now vested after September in the aunt. So she had the power of possession, she had the power of control. Yes. And in fact, my Lord, where did she put power? So, my Lord, in fact, it does not seem to take into account, unless you are a joint owner, part ownership. My Lord, may I proceed?
Please do.
Thank you very much, my Lord. My Lord, we therefore submit that the Act considers a change of possession, and as my Lord rightly pointed out, to a new owner. And we submit that the facts and circumstances of this case pointed to the aunt as being the new owner, and therefore it was incumbent on Mr. Raphael to transfer within 7 days. And that would have satisfied the statutory requirements. The unexplained failure I think it's simply summed up as we did not meet. To transfer certainly does not satisfy the provisions. It would mean, therefore, that a person who has not properly transferred the vehicle should not use the cars on the public roads of this country. Because, my lord, it would open the gates to allow for a breach of the Act by anyone who simply declines to attend the licensing authority for whatever reason outside of the 7 days, which would be unlawful. My lord, I referred a little while ago to the question of part owner, and that is because in the opinion of the learned trial judge, as she then was, at page 398, about 3 lines from the bottom, Lord, and I apologize not having the exact line number. According to him, he did so because he was still the owner. He accepts, however, that his aunt was a part owner. And Lord, that is reflected in the evidence as well, I think. I shall have someone pull it up for me very quickly for my Lord's reference.
I'm not sure if we can attach much weight to the second respondent's understanding of the law, given the fact that it's recorded that the gentleman couldn't read. But I have the point that that was his evidence.
Certainly, my lord. And my lord, this is a person who, even though he couldn't read, seemed to understand that there was a need for his expression, good faith. Because he says that he signed it and he did not want the word paid out of good faith. Lord, I've just lost my note for a second. We therefore submit, my lord, that ownership is not limited to registration, and it was necessary for the trial judge to analyze the facts and circumstances to determine, first of all, when did property pass, when did title pass, and 2, whether or not the inconsistent finding of a part ownership or a co-ownership in itself would be inconsistent with the definition under the Road Traffic Act, that the Act itself recognizes that there can be gaps in ownership, and therefore the 7-day period must be complied with. Yeah, so my lord, just bear with me a second. And of course, my lord, if the vehicle had been destroyed by another person, well, then the question would be who would have the right to claim under that insurance policy. Regretfully, this is an own damage matter, and the vehicle ran off the road, so there was happily no other vehicles involved. So, my lord, that is the first difficulty we have. There was no analysis of when did the title pass, and therefore there could be no absolute conclusion who was the owner and who was in possession of control. There was further no analysis of the obvious weaknesses and inconsistencies. And Lord, I know I'm trespassing in here to a concurrent finding of fact, but I wish to, Lord, that there's the absence of an analysis of the weaknesses by the trial judge was certainly something that should have been considered in determining whether, in fact, he was reliable on the question of being the registered owner. The most obvious conflict obviously arose with the receipt for $75,000, which was a contemporaneous note of the agreement, and which seems on its face to suggest that the $75,000 was received by Mr. Ramphal in September 2010. Now, we suggest that this was in fact a prior inconsistent statement, because
Mr. Rajkumar, did the counsel appearing for the insurance company challenge the veracity of the second respondent's assertion that he was paying by installments? He was being paid by installments.
Yes, he did, my lord, and I will, Mr. Tiller, Because, oh, sorry, I'm just being reminded remarkably that it was a she, my lord.
She.
Thank you, my lord. But it was challenged, and it was challenged in light of the first statement of the second respondent that was given to the insurance company, in which, first of all, the receipt, well, I'm just getting it on the record for you. The receipt itself was a full set out, full receipt of payment. The first statement of Raphael to the insurance company in 2011. In 2011, that was read to him, and he accepted all that was true, save he said that he told them about the payment plan and it was not recorded. But there was no mention in that first statement of any payment plan, 3045. His witness statement, and just to point out in the electronic bundle at page 339, from line 29, and it continues, my lord, to page I'm just making sure, my lord, it seems to go all the way across examination to page 343, line 23.
Thank you.
There was also, my lord, the remarkable evidence of 2 attempts to transfer the vehicle. No date could be recalled, and my lord would see that at the electronic bundle, page 345, lines 5 to 9 and line 27. And that, my lord, shows, we say, shows the conduct and the failed attempts to transfer because title had passed. And the challenge, my lord, to the veracity of the receipt of his evidence that amounted, my lord, to a prior inconsistent statement that went to his reliability and credibility. Now, my lord, assuming that I am incorrect and the board is not in agreement with me on my submissions on ownership, may I then move on to the other part of the argument, unless there are any questions I may answer?
Please move to any questions. No, and please move on.
So could I just?
Oh, Lord Barrows.
My lord.
Could I take you back to the definition of owner in the Road Traffic Act at electronic bundle 1198? Because I'm not entirely clear what your submission is about the relationship between ownership and registration of ownership. So,
my lord, may I put it this? I'm sorry, my lord. I apologize.
Yeah. So we're told that in the case of a vehicle that is registered, the owner means the person in whose name the vehicle is registered. Now, what have your submissions so far told us about that definition?
Thank you very much, my lord. My lord, that the definition of the Road Traffic Act at section 2 relates to the need for registration under that act. Now, my lord, if you go to section 12 of the act, the registration of a motor vehicle is a statutory requirement governed by section 12 in part 2. That section says that that all vehicles on the road must be registered. And in fact, my lord, at subsection 3 of section 12, it empowers a police officer or a licensing officer to seize and detain a vehicle that has not been registered. And it shifts, and I think this is probably the difficulty at the trial, and at subsection 4, and I think this is the difficulty counsel may have had at the trial, an incorrect interpretation of section 12. And for the purposes of the Road Traffic Act, the certified copy shall be prima facie evidence that the vehicle to which it refers has been registered. So it is for the purpose of the registration. And at subsection 6, this section shifts the onus of proof that the vehicle has been registered to the owner of the vehicle. So it makes a distinction internally as to ownership and registered owner. A registered owner for the purposes of this act is the person on the registered documents.
And what is your submission about that at the particular time of the accident? Who was the registered owner in your submission?
My Lord, my Lord Borrows, I take this somewhat frankly and frontally. Having seen certain documents, I find it difficult to submit to the court that at the time of the accident, the registered owner was Mr. Ramphal. I think I would be misleading the court. The registered document the registration documents that I have seen as counsel appearing before you puts the registered owner someone called Chantal Henry. Harry, Chantal, thank you. And that is that's a difficulty, my lord, and why I put those documents before the board.
Thank you.
Now, my lord, we say, of course, that the ownership is more expansive under the Third Party Risks Act and includes the person in possession and control. Yeah, yes, my lord, and I refer you to the case of Advantage General Insurance Company. I'm grateful for my friends for providing this. And it's electronic bundle, page 0757. Out of the jurisdiction of Jamaica. Out of the jurisdiction of Jamaica. It's a Court of Appeal decision, my lords. And in that case, on its peculiar... Sorry, my lord.
Could you give me the electronic bundle number again, please?
EB 0757.
757.
That's correct. Oh, my lord, again, I've got 774. I apologize, my lord. It's EB 774. My apologies, my lord. Sorry. The first case in the index, my lord. And my lord, that is a case where the legal or registered owner was held not to be the owner in peculiar circumstances. And I would ask my lords to look at that in the fullness of time.
In a nutshell, why was the person not held to be the owner?
It had been purchased in one person's name, and the other person, it was registered in one person's name. She never paid or provided the purchase money for the vehicle, and it was kept by another person in their custody and control.
Thank you.
My lord, in the event, remarkably, my lord, and I use the word remarkably very guardedly, the insurance policy effected in 2010 was renewed in December by Ramphal going back to the insurance company, and I suspect paying the appropriate premium. Our position, relying on the Peters case and repeating what was said in the Court of Appeal, is that upon the changing of ownership, the original policy would have lapsed or become void, and there was, first of all, nothing to renew. Given that I may be wrong, or if I am wrong in that submission, and there was a policy in existence then the court would have to decide whether or not that policy attached to the driver at the time of the accident.
Why do you say that?
Well, my lord, the certificate of insurance, which appears in the electronic bundle 0083.
Now, Mr. Rajkumar, are you moving on to section 4, 7 and 10 of the Act?
I am indeed, my lord.
How is that issue properly before the board at all? The preliminary issue that was raised at the outset, as I recall, was twofold. whether there was a valid insurance policy, and whether there was material non-disclosure. Before the Court of Appeal, the sole issue came to be whether whether the second respondent had an insurable interest. And the order that is being appealed against is a finding in relation to insurable interest, is it not?
It is, my lord. My lord, well, then I should proceed.
And did you not attempt to raise before the Court of Appeal the question of Section 4.7 and Section 10 of the Act?
Yes, we did, my lord.
And did the Court of Appeal decline to hear you on the basis that it wasn't within the scope of the preliminary issue?
Lord, I'm certain. I'm not sure, my lord. I think that is accurate. I just want to make sure. But I think that it was held to be not within the scope of the issue.
Yes. Well, I mean, before I, unless you want to make any submission as to why you should be entitled to raise a matter which is not within the scope of the issue, then I'd like to hear briefly from Mr. Prasad on this issue. Is there anything you want to say to justify raising before the board a matter that isn't in the order appealed again?
Sorry. Well, the only issue is the question of insurable interest, and whether or not there was an insurable interest, and whether or not the policy could have attached to an insurable interest if it did exist. But I can't see it going beyond that, my lord.
How does the second issue arise on the preliminary issues that were raised at first instance and in the Court of Appeal?
It doesn't, you know. My lord, I can't say it does arise, my lord, save and except as I have earlier indicated.
Yes, well, if I could interrupt you for a moment, and I'll hear from Mr. Prasad on that point. Mr. Prasad.
My lord, I am obliged. Now, I have addressed this issue in the written case of the first respondent from EB 0760. Now, essentially, this issue, whether or not the person driving at the time of the accident was authorized to do so, he had permission, was not an issue within the pleaded case at all from inception. It certainly was not encompassed in paragraphs 5 and 6, which encapsulated the preliminary issues which were before the court. Thereafter, it did not arise. Now, quite apart from it not being pleaded, the issue of whether this issue, which I would call the driver's issue, was in fact subsequently determined by the final order of the court, which dealt with liability, and that's the November order, from which there has been no appeal to the board. So there is an order existing which has determined that issue. This issue, the driver's issue, was never agitated either before the trial judge or before the Court of Appeal. An attempt had been made by counsel appearing before the Court of Appeal to introduce this issue on the morning of the trial. And my lord, it was not allowed. When your lordship has regard to the grounds of appeal in the judgment of the Court of Appeal, no such issue is cited. So that in the courts below, this issue, I submit very rightly, was never considered because it was never an issue in the case. And so it would be wrong for it to be agitated at this stage. In synopsis, that is my position on this issue.
Mr. Prasad, thank you for your succinct statement. Mr. Rajkumar.
My lord, may I simply point out that at page 64 of the electronic bundle, it was not part of the preliminary issues, but it was an issue raised on the pleadings at paragraph 8. The second, may I quote, my lord, the second defendant also denies the vehicle was negligently driven or managed by the first defendant, his servant and or agent and or unauthorized driver.
Which page is that, please?
Page 64 of the electronic bundle, my lord, paragraph
Paragraph?
8 of the statement of claim, of the defense. I'm sorry, my lord.
Yes, just bear with me. I'll bring it up.
Certainly.
And that's right. I looked at it yesterday, and it goes on to say the second defendant will contend that the said vehicle was not driven by the first defendant since the date it was sold. If you expand paragraph 8 and we go to the witness statement of Mr. Hulas at, I think it's MS1 EB176.
Yes, my lord. Yes, my lord.
You see at the bottom, you seek a declaration that they're entitled to avoid for non-disclosure, and over the page, a declaration that they are solely and responsible. And if I remember right, I'll just have to find the relevant passage, but if I remember Mr. Hulas's statement, the contention was that the driver involved in the accident couldn't have been a permitted driver or agent because the car had already been sold. And we find that at page 180, EB 180, at paragraph 10.3.
Yes, my lord.
Yes, so I mean, the claim that was being made was that the driver couldn't have had the permission of the owner because the second respondent, then first defendant, was no longer the owner and couldn't give permission. One was not investigating as a question of fact on the hypothesis that the second respondent was an owner, he had or had not given permission. That wasn't the case that was pleaded.
Yes, my lord.
Yeah. Well, I think the board had better adjourn briefly to consider these submissions, unless any of my colleagues wishes to raise anything at this moment. No. Okay, we will adjourn the meeting and we will return within the next 10 minutes. Thank you.
Much obliged.
We are continuing the hearing in the appeal by Presidential Insurance Company. Mr. Rajkumar, the board has considered the question whether you should be allowed to advance the argument under section 4.7 and 10 of the Act, and we have concluded that there is no basis for us to consider that matter on the appeal that is before us. So if there are other submissions you wish to make, please do, but that matter is not to be addressed.
My lord, in the circumstances, I'm guided, and I suspect, my lord, that there are no further submissions unless you wish to hear me on anything else. Okay.
I'll see if my colleagues wish to raise anything. No, I don't think so. Well, in that case, we will adjourn again briefly to consider what matters we wish to hear Mr. Prasad address us upon. We will return within 5 minutes. Thank you very much indeed. This is the resumed hearing in Presidential Insurance Company Limited appeal. Mr. Prasad, the board has deliberated and we've decided that we do not need to call upon you for your submissions. Thank you very much.
I wonder whether I may correct the appearance. It appears that I did not properly indicate. I appear with Mr. Sean Ryan and Mr. Ronaldo.
Right.
I'm obliged.
There's nothing else you wish to add?
No, please.
Thank you very much. Well, the board is very grateful to council for their written and oral submissions. And the board would also like to thank those who've assisted council in the preparation of the materials for this appeal. The board will consider the submissions and produce a judgment in due course. The board will now adjourn.
Obliged.